Hi, we are back with your favorite talk show, Namibia at Work. Good day and welcome to yet another episode of Namibia at Work. On this talk show, we share information on the development within the Ministry of Labour, Industrial Relations and Employment Creation. I am Maria Hedimbi, your host for today. The Office of the Labour Commissioner recently announced that a considerable number of trade unions and employers' organizations have not submitted their annual returns. Disappointingly, some have not even submitted a single annual return since their registration is required by Section 60 of the Labour Act, Act No. 11 of 2007. Today, we have the privilege to be joined by the Acting Labour Commissioner, Ms. Kyllikki Sihlahla. Ms. Sihlahla, welcome to the talk show.
Thanks very much, Maria, for having me.
Ms. Sihlahla, before we dive into the subject, could you briefly tell our viewers about the difference between trade unions and employers' organizations?
Okay, Maria. Trade unions and employers' organizations are two distinct types of organizations that represent the interests of different stakeholders in the labor market. Overall, trade unions and employers' organizations play distinct roles in the labor market, with one representing the interests of the employees, while the other one representing the interests of employers. However, their interaction can have a significant impact on labor relations and the broader economic landscape. In terms of representation of interest, trade unions represent the interests of employees. They are formed by workers to collectively bargain for better wages, working conditions and benefits, as well as to deal with issues at workplace such as safety concerns and job security. Okay. While employers' organizations, they represent the interest of employers. They are formed by employers to advocate for their concerns, such as labor laws and regulations. And we also touch on the membership. Members of trade unions are typically employees who join the union to have a collective voice and negotiate with their employers for better terms and conditions of employment. While the members of employers' organizations are usually employers. Okay. These organizations are typically composed of employers who come together to collaborate on issues that affect their businesses. We can also maybe look at their goals and objectives. Trade unions primarily aim to protect and advance the rights and interests of workers. Okay. They negotiate with employers on matters such as wage, benefits, working hour, and workplace safety. That is now their objectives and goals. While the employers' organizations, they work to protect and advance the interest of employers. They often advocate for policies and regulations that promote a favorable business environment. Okay, we also look at negotiation and bargaining. Trade unions engage in collective bargaining with employers to negotiate employment terms and conditions. This can include negotiations on wages and any other labor-related matters. Employers' organizations may engage in negotiations with trade unions or government bodies on behalf of their members' businesses. Okay. They advocate for policies and regulation that are favorable to the employers. Okay. So in short, those would be the difference between the two institutions.
Okay, thank you very much for that clarification. Now, you just spoke to us about the definition between the two. Can you just tell us about how many trade unions and employers' organizations are on the Commission's registry records? And perhaps just to look at what does this has to say about freedom of association in terms of labor?
We currently have 47 registered trade unions and 17 employers' organizations. And the fact that we have those, that indicates a diverse landscape of labor and business associations. This suggests that individuals and entities have the freedom to form and join these organizations to represent their interests. And in terms of freedom of association, a relatively high number of registered organizations typically implies that there is a degree of freedom of association in Namibia. It also suggests that workers and employers have the ability to come together to protect and advance their respective interests without significant legal or administrative barriers. And again, these organizations are registered by the Labor Commissioner. That indicates that they have legal recognition and can engage in various labor-related activities such as collective bargaining, negotiations, and advocacy. We can say in summary, the registration of 47 trade unions and 17 employers' organizations by the Office of the Labor Commissioner suggests a relatively open environment for freedom of association and representation in labor and business.
Wow, that is a quite interesting number. Now, Ms. Sihlahla, can you just take us through? The Office of the Labor Commissioner has recently announced that majority of trade unions and employers' organizations are not complying with the provision of the law that is now in terms of submitting their annual returns to the Labor Commissioner. What does this mean really to us, the viewers?
The announcement by the Office of the Labor Commissioner that a majority of trade unions and employers' organizations are not complying with the provisions of the law by failing to submit their annual returns has several implications. Number one, we talk about the legal compliance. So if they fail to submit annual returns as required by the law, that would suggest that these organizations are not adhering to their legal obligations.
Okay.
Annual returns are typically a mandatory requirements in our country in order to maintain legal recognition and status as trade unions and employers' organization. Then we look also at the issue of accountability and transparency.
Okay.
Annual returns often include financial statements, membership records, and other relevant information about the organization's activities. So submitting these returns is a way to demonstrate transparency and accountability to both members and regulatory authorities, like the Office of the Labor Commissioner. The other issue is also loss of legal status. You know, non-compliance with the requirements to submit annual returns could result in legal consequences. And then we also look at the issue of trust and credibility. You know, if they fail to submit annual returns, can erode trust and credibility among members and stakeholders. Members may question the organization's financial management, and stakeholder may doubt its commitment to operating transparently and responsibly. And the other issue also, the impact on representation. Without complying with legal requirements, trade unions and employers' organizations may find it difficult to effectively represent their members' interests in labor negotiations, advocacy, and other activities. And this can also weaken their ability to achieve their goals and objectives.
Wow, very much interesting. Now, can you just tell us why is it important for trade unions and employers' organizations to submit their annual return to the Labor Commissioner?
Submitting annual returns is a fundamental aspect of good governance and sound management for both trade unions and employers' organizations. This ensures compliance with the law. It enhances transparency and accountability, and it also helps maintain trust and confidence among members and stakeholders, and it contributes also to the overall integrity of these organizations in the labor market. And the submission of annual returns is a legal requirement. So with regard to transparency and accountability, annual returns typically include financial statements, membership records, and other relevant information about the organization activities So by submitting these returns, trade unions and employer organizations demonstrate transparency and accountability to their members, stakeholders, and the public at large. It allows members to assess how their dues and contributions are being used and whether the organization is managing its finances responsibly. The other issue is also member trust. Members of trade unions and employers organizations place their trust in the organization to represent their interest effectively. So submitting annual returns can help maintain and strengthen this trust. In accordance with Section 60E of the Labour Act, Act number 11 of 2007, and the Rule 10 of the rules relating to the conduct of conciliation and arbitration before the Labour Commissioner, it is mandatory for every registered employer and registered trade union to submit an annual return to the Labour Commissioner. These annual returns must include a statement of income and expenditure for the respective year, a balance sheet reflecting the financial position at the year's conclusion, and an annual audit report. The audit report should be prepared by either a registered public accountant and auditor or an auditor approved by the Labour Commissioner. These documents are required to be submitted to the Labour Commissioner within 6 months following the conclusion of the organization's financial year. And you have to utilize the prescribed form, which is Form LC 09.
Okay. So now, what is the due date for these defaulting entities to submit their annual returns to the Labour Commissioner?
Okay, we have given really them enough time, and they are required to submit on or before the 30th of November 2023.
So typically they only have few days before they submit their annual returns to the Labour Commissioner. Okay, now based on a narrative, one can conclude that majority of these institutions are in contravention with applicable statutory obligation. Are there any consequence for these non-compliant trade unions and employers organizations? And if so, what are these consequences?
Absolutely so. According to Section 61, subsection 4 of the Labour Act, any entity that fails to meet its obligation stands at risk of having its registration cancelled. And that we mean by deregistration by the Labour Commissioner. Alternatively, the Labour Court may suspend the entity's registration pending compliance, and they do so if they are approached by the Labour Commissioner.
Okay, thank you for that clarification. Now, before we let you go, is there any final remark that you want to share with our viewers?
I think I have said it all. However, the trade unions and the employers organizations, they are well aware because they have been reminded several times, and I'm just urging them to heed the call so that they do not face deregistration. And if they have forgotten maybe their obligations, they should just consult the Labour Act because their legal obligations are clearly stipulated there.
Thank you very much for that.
You're more than welcome, Maria.
Well, we have come to the end of our program. Please do join us next time as we bring you yet another educative and informative session of Namibia at Work. And please don't forget to follow our social media platforms. We are on Facebook, Instagram, Twitter, and YouTube. We would like to thank Ms. Sihlahla for joining us today in this program. With that, we come to the end of this show. Until next time, it's goodbye.